in my case, was the difference between a multi-year state prison sentence and client walking free. I had a recent case in a county, a client charged with DUI facing a mandatory minimum year in jail, potentially several more. And in that case, law enforcement at the district attorney's suggestion or direction suggested to my client that while the DUI penalties associated with a DUI conviction wouldn't be enhanced, if the client refused consent to the blood draw, law enforcement would obtain a search warrant and charge client with additional crimes if consent to the blood draw was not provided. A blood draw is a search under the Fourth Amendment, and so generally that search has to be supported by a search warrant, unless an exception to the warrant, a requirement applies, such as your consent to the search. The United States Supreme Court held several years ago now that law enforcement cannot threaten to enhance criminal penalties if you refuse consent to that blood draw in order to induce you to give consent and waive that warrant requirement. So we made the argument to the judge, Your Honor, they're not threatening enhanced criminal penalties on the DUI itself, but they're threatening additional criminal charges. The same idea, you can't threaten additional criminal penalties to coerce consent to a blood draw and waive the warrant requirement. And the judge agreed. So in this county, that policy of threatening additional criminal charges if consent to a blood draw was refused was ruled unconstitutional, and law enforcement there had to rethink how they investigate DUI cases. If you were arrested for DUI and your blood was drawn in connection with the investigation into your blood alcohol concentration, it may be helpful to seek legal advice to review the circumstances of that blood draw and whether it complied with the Fourth Amendment's prohibitions against unreasonable searches. The effect on the ultimate outcome of your case could be significant.